My apologies, Mills.
No worries.
Something.
Right.
That's as good as it got. Thank you.
Yes. You've all been sitting too still, that's all it is. All the lights go out.
Riveted.
I thought they stopped that. I remember when I was first in this building
Oh,
in 2001, both Lady Justice Asplin and I were first. If you sat still in your room for more than about 5 minutes, all the lights went out. Not that I ever sit still for more than 5 minutes. Okay.
I'll try and bob around a little just to keep them going. But, my lord, my ladies, if I may have 2 minutes just to summarise the position from this morning, or my submission from this morning, before moving on to deal with really quickly the competent court questions. The easiest example would be a case where the county court orders a payment with the benefit of the decision of the ombudsman. In that case, there's no doubt at all that the county court, competent court, has made an order under which the monetary obligation is enforceable. Set-offs, it is, Mr. Justice Leach held, it was sufficient to get a declaration saying the money can be recovered. In my submission, it's a slight stretch of language to say that is enforcing the monetary obligation to pay £100, but that's the position. So if the county court gives an order to that effect, that's certainly an order of a competent court. Much of this morning was taken up with the question of how the county court does that and whether it involves a judicial act or an administrative act. I must say in my submission this is that's outside the scope of Mr. Justice Leach's order and wasn't something that was considered. Not that means I'm suggesting it shouldn't be dealt with, but it is not always going to be easy. And although it's been put to me, what about the position if there is a paragraph that is very clearly a determination? In my submission, things may be different going forwards when the Ombudsman's had the benefit of hearing this argument and the benefit of my lord, my lady's judgment. But the difficulty sometimes of picking different elements of a narrative decision and saying this can be enforced and this can't isn't to be underestimated. And although a determination can be enforced in the same way as if it was a judgment or order of the court, the county court, I do go back to the submission I made earlier, which is the fact that one has a judgment, a narrative judgment that says many things, will not allow the claimant or defendant, as the case may be, to enforce every line in that judgment. And one is aware of cases where there is a judgment on something, deals with a number of issues, and then later it becomes apparent that a remedy is sought that hadn't been sought in the first proceedings, but which relies entirely on a judgment and is said to be res judicata, so that the issues can't be reopened. And in those circumstances, another judicial act, X against Y number 2, will result in an order being made on the basis of the previous narrative judgment that isn't simply an administrative act. But all of those questions arise because in my submission, the Pensions Ombudsman is not a court or a competent court for the purposes of section 91(6), so that its decision isn't the order anticipated and required by 91(6), And in a moment, I'll turn to those two questions very briefly. Before I do that, perhaps I should address the point. I've sought to address it in passing. In my submission, section 91(6) does require there to be that order. And although enforceable as a matter of language, I suppose, could be construed as meaning would be enforceable if an order was obtained. In my submission, that can't be right, because that would be the case whenever there actually has been an overpayment. If you don't need the order, a party, a trustee could say, we're entitled to an order from the court, therefore we don't need to get one. So there must actually be an order from the competent court, and that, we say, is the county court. Now, going to what on my notes is said to be the first question, that is whether the Pensions Ombudsman is a court. And that question is, as I've set it out, the question isn't whether it's like a court or more like a court than other ombudsmen. And the moment one starts weighing various features to say, well, it's quite like a court in these ways and not like a court in these ways, and balancing up whether it's more like a court than not, simply underlines the fact that it's not a court. The fact that you're doing that comparison points very much against an answer in the affirmative. Now, some of the cases, such as the employment tribunal cases, the higher courts did consider the details to see which side of the line it fell. But in those cases, one already had a situation where the basic structure, the basic function, was that of a court. So in an employment tribunal, for example, the parties come in, claimants sit on one side, respondents sit on the other side, parties decide what evidence they're going to call, they're cross-examined, and ultimately the tribunal, at least one of whom is a legally qualified person appointed by the Lord Chancellor. In fact, I think all three are now, where you have a panel, all three people are appointed by the Lord Chancellor. Although that wasn't the case in 1995, when the lay members were appointed by the Secretary of State. But that person makes a decision. And anyone observing from the outside would not be surprised if that was described as being a court. That's very different to a typical case before the Pensions Ombudsman, which is in almost every case conducted through correspondence. That correspondence isn't always copied to both parties, and although there can be an oral hearing, they are very rare. In the Weber decision, at least the Weber decision of Mr. Justice Nuji, as he was, that particular case was considered by various people at various times. I think the figures there are about one oral hearing a year as opposed to about 1,000 cases, or just under 1,000 cases a year. So it is, we start off with a body that simply doesn't look like a court. And the cases, in the cases, the judgments have consistently and repeatedly distinguished between courts on the one hand and the Pensions Ombudsman on the other. Now, we've set out paragraph 26 of the skeleton, and that's page 50 of the core bundle. Many of these references. And
paragraph, I'm sorry.
50.
Page 50, paragraph 28.
26. Page 50, paragraph 26. Yeah. and the underlying cases are in the bundle, but bearing in mind where we are for time, unless it would be helpful, I'll simply rely on what's set out in the skeleton. You see what was said by Mr. Justice Carnworth, as he was in Miller and Stapleton. He talks about some functions being similar to that of a court, that's resolving, deciding points of fact or law, but investigations of maladministration are not the normal function of a court. At B, when that case had permission to appeal, Lord Justice Peter Gibson says that various rules requiring courts or tribunals to be given notice and yet of an appeal, but it being unthinkable that they should be parties to an appeal. Lord Justice Peter Gibson says those rules seem to me to be plainly distinguishable from the present case. All rules pertaining to persons performing judicial functions in courts or tribunals. Westminster Council and Hayward, Webber against the Department of Employment, Burgess and Bick, and then Booth. I'm not going to read them out to the court. For what is worth, I hadn't made reference to two cases relied on by my learned friend. One's Wakelin, which is at tab 3, where similar points are made by Lord Justice Pill, dissenting but not on this point, at paragraphs 87 and 88. And in the case of R.J. Wiggins, which is tab 6, page 125, paragraphs 13, 14 and 24. I'm not running through them quickly for now, but time and time again the courts have said the Pension Ombudsman is not a court. Now that may be an ordinary use of language rather than being expressly directed section 91(6), but it's an extremely well-informed use of language, and the language itself is the starting point to see what is meant in section 91(6). I will turn to BIC in slightly more detail. This is in tab 4 of the bundle of authorities, and page 57, I'm sorry,
It's the first page.
yes, no, page 90, thank you. Page 90 of the bundle of authorities, paragraph 132, Mr. Justice Arnold, as he was, says, having made a decision in relation to the pre-97 increases, in case I am wrong about that, I shall go on to consider the other routes relied upon by the claimants. Now, the skeleton arguments deal with the question of whether this was ratio or obiter in those circumstances. Of course, it doesn't matter.
Well, it doesn't matter before this court, but it seemed to me it's a classic case where there were two possible lines of reasoning, and the judge dealt with them both, and on appeal he was overturned on the first one, but because he decided the case in the alternative on the second, the decision stood.
Yes.
And that's a classic case of part of the ratio.
My lord, yeah, that was my submission. It, of course, doesn't matter for this.
It doesn't
court.
matter, but
He hadn't said, Mr. Justice Arnold hadn't said, I don't need to decide this issue, my provisional thoughts
quite.
are X. He made a decision. But perhaps more importantly, when he came on to deal with this as a matter of substance, he starts that at page 92, paragraph 149. And Paragraph 168, his conclusion, he says, in my judgment, determination by the Pension Ombudsman would not itself constitute an order of a competent court because the Ombudsman is not a court. Full stop. He's right. He then goes on to say an order by the County Court pursuant to Section 155A of the Pension Schemes Act would constitute an order of a competent court, however. And certainly subject to the question of whether that's obtained administratively or judicially, a question with which Mr. Justice Arnold wasn't troubled, it may be that's the correct position and remains the correct position. But in my submission, as a matter of ordinary language, the Ombudsman isn't a court. The cases on whether the Employment Tribunal is or isn't a court is of limited value, particularly because, as Lord Justice Bean said, with the agreement of my Lord the Chancellor, this depends upon context. That's in Watson and Hemingway Design, paragraph 23.
Well, it was the point there was the one-stop shop point about
Yes.
third-party rights against the Insurers Act.
Yes.
The contrary decision would have meant that well, it would have defeated the object of the Act. So
Yes, it would simply not have worked.
to be obvious that in context, the Court of Appeal considered that courts included
Yes.
the employment tribunal.
So, well, I say that doesn't assist. If here, notwithstanding what I say is a fundamental difference between the Ombudsman, a function of the Ombudsman, and those of courts, as ordinarily understood, if a comparative exercise is to be compared, the differences are such that it should not be regarded, or he should not be regarded as a court. He investigates rather than simply adjudicating on matters put before him. The appointment isn't an appointment made by the Lord Chancellor or through the Judicial Appointments Committee. One point is the fact that the Pensions Ombudsman has written articles in the past. You have the article by Professor Farrand, who passed away recently, at tab 35. I'm not going to go to it, and the fact sheet by the previous Ombudsman that were critical of decisions that have been reached in the Chancery Division. I'm not suggesting for one moment that they shouldn't have produced them, but it's not very court-like for a lower court to produce an article or a fact sheet saying a higher court got it wrong. Ombudsman can be a party to an appeal, which is very different. But these are, I say, these would all push the Ombudsman away from being a court if it was close to the line, but I say it's not even close to the line in the first place. So unless I can take those submissions further, I say Mr. Justice Arnold was quite right when he said the Ombudsman isn't a court. The Ombudsman isn't a competent court, even if it is a court, because it cannot itself enforce the monetary obligation. And that really goes back to the discussion that was had earlier today. Obviously, the word competent in the phrase competent court is a jurisdictional question rather than anything else. There's some authority to that, but it may be that that's so obvious to go without saying. So because the Ombudsman cannot require payments to be made by the member, certainly it wasn't a competent court before 2005 when we were only ever talking about obligations arising from criminal behaviour, etc., save in the narrow case of trustees. And that fact wasn't changed when section 91(5)(f) was introduced. Now, that's a whistle-stop tour of the submissions made in more detail in our skeleton argument. What I would say before pausing, just as a matter of policy, in my submission it would be odd if the decision of the Ombudsman himself satisfied 91.6 for a number of reasons. One, there will be a real difficulty sometimes in distinguishing what is a determination and what is reasons. But perhaps more than that, if the Ombudsman is the proper place to determine these issues, then legislation would be desirable, allowing the Ombudsman to do that generally. At the moment, on any basis, it really only happens as a matter of chance if the member complains to the Ombudsman. And in my submission, it would be unfortunate if the Ombudsman is the proper jurisdiction or the proper place for these issues to be looked at. It would be unfortunate if the Ombudsman isn't allowed to look at them on behalf of trustees as well as members. And so the piecemeal development of the law, stretching the language in section 91.6 in order to bring the Ombudsman within the scope of competent court, in my submission would be undesirable, and any legislation could also deal with the point that it is not always easy to distinguish between the determination and the reasons, and to deal with any lacunae in the enforcement mechanism before the county court. Now, if I can have just one moment. Unless I can assist further, those are my submissions.
Thank you very much, Mr. Short.
Dealing first with my learned friend's first point that was dealt with this morning, it seems to us that it boils down to three propositions. Firstly, that the matters that are relevant to deciding the issues of overpayment and recoupment are dealt with in the reasons for the determination rather than the directions. The learned friend's second point was you can only enforce directions and not reasons. And the third point was that the Ombudsman can't direct the trustees to be permitted to recoup, because the only thing the Ombudsman can do is direct the trustee to take or refrain from taking steps. Now, at first, we took my learned friend to be getting quite close to contending that the Ombudsman had no jurisdiction to deal with overpayment disputes. And that was something which I was going to raise before the short adjournment if your Lordship and your Ladyships hadn't raised that with my learned friend towards the end of the short adjournment. It seems to us that the learned friend's case now, whether this is wobbling or not wobbling, I'll leave out of it, is that the Ombudsman does have jurisdiction to deal with the overpayment and recoupment issues in the determination. But where the decision is that the trustee can recoup, that decision can't be enforced under section 1515. We say that's wrong for a number of reasons. Firstly, this is a point which the court made several times during my learned friend's submissions, section 1515 permits the enforcement of determinations as well as directions, and not just directions. And we submit real effect ought to be given to that. Section 1515 shouldn't be limited by what the subordinate legislation, the enforcement regulations, may make provision for, although in our respectful submission we agree with my Lady Justice Whipple that there is in fact no inconsistency between the two, given the width of Rule 3, dealing with non-monetary obligations. In our submission, for the purposes of section 1515, the determination is the Ombudsman's decision as to whether or not there has been an overpayment, whether there are any defences to the overpayment, whether the trustee can recoup.
Sorry, decision about whether there was an overpayment.
I'm sorry. Decision whether there has been an overpayment, then whether there are any defences to overpayment, such as change of position, whether the trustee can recoup, and if so, the amount and timing of the recoupment. As to that last point, I should just say to your lordships, that in practice, what happens is that the ordinary direction when recoupment is ordered is that in our submission very sensibly, although we would say this, wouldn't we? What the Ombudsman does is invite the member and the trustee to meet or to correspond in order to work out a payment schedule or recoupment schedule which is suitable for both of them. And in default of that, then they go back to the Ombudsman for a specific direction. Yeah.
Is that schedule then made the subject of a direction, or is it just left between the parties?
It's left between the parties. There isn't a formal direction made in that respect. We say it's artificial to distinguish between the determination and the reasons for the determination. And the court will have in mind that the determination process is meant to be relatively informal. The Ombudsman's duty is to be writing determinations which are capable of being understood by the member, easily understood by the member. And for that reason, the Ombudsman does not adhere to the kind of formal requirements that a High Court or a County Court has. For example, the distinction between a judgment and an order. Yeah. That's just not how it's done. In our submission, the learned friend submissions are really attacking for our submission, very good reasons, the relatively informal way in which a determination is written for the benefit, primarily, of the member complainant. Now, as to the submission that the Ombudsman doesn't have the power to permit the trustee to recoup because his power under section 1512 is to direct trustees to take or refrain from taking steps. The short answer to that is that it entails a hair-splittingly literal approach to the Ombudsman's powers under section 1512. In our submission, it is obvious that if the Ombudsman can direct a trustee to do X, or direct a trustee not to do X, then he must be able to direct the trustee that he can do X if they consider it to be appropriate. And if it's necessary, we would submit that that interpretation is required to give purposive effect the Ombudsman's ability to resolve disputes without any artificial limitation being placed on the available relief.
How realistic is it to think that you might have a trustee who's gone all the way through a dispute with the pension ombudsman who isn't at the end of the day looking for a direction about the amount that they need to deduct month by month, if that's where they get to? I mean, is it realistic to think there might be trustees who go, please don't give us a direction about that because we want to exercise discretion at this stage not to recoup?
Well, the discretion is normally about how to recoup.
Yeah.
It may be that at the time of the complaint, the trustees were not in a position, because they didn't know about the financial circumstances of the member, etc., to know over what period they would seek to recoup. Because obviously the shorter period, the more the member's deductions being made. So it's not necessarily a question of whether, it's a question of how.
So you might have, I'm just trying to think of an analogy, in costs you might well get an order that said that the trustee to recoup £100 in such manner and over such term as may be agreed between the parties, something like that.
Yes. Yes.
And that's, you do see that kind of order in ordinary life,
Yes.
outside the pensions jurisdiction, don't you?
Yes, but what the Ombudsman is strives to do at all times is to act within the scope of his powers in as flexible and user-friendly way as possible. And in a situation where the trustee is in a position where they need to recoup overpayments, the member is in a position where that could cause them considerable hardship, then the Ombudsman will do what he can to ensure that both parties are, if at least not satisfied, at least not overly dissatisfied. In our submission to limit the jurisdiction of the Ombudsman to act in those terms is contrary to the policy, the purposive effect, the purpose of the Ombudsman jurisdiction. Now, the alternative answer to that is this is simply a distinction without a difference. Let's assume the trustee's right that the Ombudsman can only make orders in mandatory or prohibitory form. In our submission, that wouldn't prevent Section 91(6) from being complied with in a recoupment case, because all that would be required would be for the trustee to put before the Ombudsman a proposed schedule of recoupment and the basis for it considering that it should recoup, and then the Ombudsman can direct the trustee to carry out that schedule.
Yeah.
And that would be proper in the circumstances where the trustee could explain why it thought it right to recoup the overpaid sums, which would usually obviously be in the interest of the scheme as a whole, and the member would then have the opportunity to contend that the trustee shouldn't seek to recoup the oversums repaid or the amounts and the rates set out in the
Such a
schedule.
case in which negotiation between the parties failed, as for example, as to a schedule of repayment, then the Ombudsman's almost certainly going to be directing the trustee that the trustee can only recover X a year or
Yes,
whatever.
because if there's a breakdown between the parties, they need a decision, and the Ombudsman's the decision maker in that situation, and that will involve a mandatory order, which undoubtedly falls within Section 1512. So,
And as my Lady Justice Whipple said, the circumstances in which trustees who've been through all of this process actually don't want to be pinned down and still want the discretion to decide not after all to recoup is fanciful.
yes, well, absolutely. But the reason why we suggest this as an alternative is that it does add an additional layer of complexity, which is why in our submission the most sensible thing will be to construe Section 152 as allowing declarations, if I can put it in a judicial phrase, as to what the trustees are permitted to do. Now, moving on, it's important that the court understands the consequences of my learned friend's submission. His case is that because the trustee can't enforce a determination permitting recoupment, enforcement isn't an administrative act, it's a judicial act. But that doesn't mean that the determination can simply be put before a judge to rubber stamp, rather than being rubber stamped by the court office. It's not a question of moving the document from one place to another within the court. If the trustee can't enforce, then the trustee will need to issue a fresh claim seeking an order of the county court for the purposes of Section 91(6). So that will require an originating process, service on the member will be given an opportunity to put in a defence, and it may require an oral hearing to determine. And in our submission, the requirement for an oral hearing, and therefore a lengthy process, isn't fanciful, because in practice, if a member receives the originating process and doesn't, as is usually the case with Ombudsman complaints, doesn't have the benefit of legal advice, they may take the opportunity to just throw a load of stuff into a defence, raising matters that may or may not have been in the original complaint, may or may not have arisen since the complaint was determined. And that would lead a county court judge, who presumably has little or no pensions experience, to have to decide what to do in that situation, to sort the wheat from the chaff. But even if ultimately the county court judge was to do that and able to do that, and if ultimately all the members' points were thrown out, that still adds considerably to the cost and delay. And as I said to your lordship and your ladyships earlier, the Ombudsman's concern in bringing this appeal is if he's not a competent court, the trustee will go to the High Court or the County Court instead of allowing a complaint to be made. Now, my Lord, the Chancellor's response was that the enforcement process would add very little to the cost and delay, and so shouldn't be a concern to the trustee. Well, if my learned friend is right, the trustee may be faced with potentially long and expensive trip to the County Court anyway, so they might as well start there. So on this point, our submission...
If he's wrong,
Yes.
the basis on which I was putting the point to you in your opening was that he was wrong, as it were, then section 91.6 is really mirroring section 1515, then it is effectively I mean, it may not be an administrative process as such, but it's a short form process, isn't it?
Well, if I could
It's
just...
not a process where the county court is revisiting the issues in the case.
Well,
because they've been decided.
If at the end of this case, the court is against us, and if the underlying basis for that is because of the court's belief that the requirement for the trustee to enforce a determination is a quick, inexpensive and essentially administrative act, then it would be very helpful if the court in its judgment would say that in terms. And I don't mean that flippantly, because obviously the Pension Ombudsman's principal concern is to ensure whatever comes out is something that is going to be useful for him and practical and clear. So I'm just throwing down that point. That doesn't mean I'm wobbling.
No, I understand the point.
So if your Lordship's premise is correct, then and it is merely administrative act, then subject to communication issues, that's something obviously that the Ombudsman would be more satisfied with than if a learned friend was correct as to the need for the trustee to issue fresh an originating process. Now, while we're on section 151, so that's what I wanted to say about the learned friend's first point. I'm not going to repeat the arguments in relation to whether or not the Ombudsman is a competent court, although that remains our principal argument. I do have one or two things to say about my learned friend's very short submissions on that this afternoon. His first point was when asking whether or not the Ombudsman is a court, seemed to us to boil down to if it looks like a court, then it is a court. Now, in our submission, that is with great respect to my learned friend, a simplistic way of looking at the matter, and not a particularly helpful one when one is seeking to have a bright line test between what is and isn't a court. And we've seen in the case of the industrial tribunal and employment tribunal cases that this is in the relevant circumstances a multifactorial exercise in relation to the context in which the issue arises. As a matter of policy, as I said this morning, the key question in our submission is the Pensions Ombudsman, does the Pensions Ombudsman constitute a forum for the effective resolution of the dispute as to the amount in question? It doesn't matter whether it's called a court or not, provided that an effective process is laid out, provided it's a fair process, provided it's an impartial process. And I have to say in passing that we do not accept that the fact that the Ombudsman may be a political rather than judicial appointment is at all relevant to this case. The fact that he's under an obligation to follow established legal principles when making determinations. And importantly, provided that the determination of the Ombudsman is final and binding on the parties, then in our submission that entirely complies with the policy of section 91.6 and should in that situation there is no reason why the Ombudsman should not be regarded as a competent court. Learned friend referred to the cases in paragraph 26. I could spend quite a lot of time going through those cases, but I'm not going to, because ultimately none of them, apart from BIC and this case, relate to section 91.6, and so are outside of the context which we're looking here, and in particular the specific policy reasons that I've already addressed your Lordship and your Ladyship's on. As far as BIC is concerned, I'm not going to get into the ratio obiter issue because it doesn't matter for this court. We would point out that my learned friend's reliance on that case, and and he took your Lordship and your Ladyship's to paragraph 168, and there's no getting around the fact that the entirety of the analysis of the learned judge in that case is encapsulated in the sentence, "In my judgment, a determination by the Pensions Ombudsman would not itself constitute an order of the competent court." In our submission, that is, with the greatest respect to Mr. Justice Arnold, perhaps not of as much assistance as regards analysis and reasoning that would perhaps inform a similar argument and decision before this court. Finally, my learned friend referred...
Paragraph 166, for example,
Yes.
is really in your favour, isn't it?
Yes.
Because 166 is really saying, well, the determination is within section 1515.
Yes. Yes.
So if there's a determination that has to be, there's been an overpayment and needs to be recoupment, it's within 1515.
Now, with all fairness, it may well be that the point my learned friend was addressing the court on this morning was not put to Mr. Justice Arnold.
Yes.
I don't know, I wasn't there, but he certainly doesn't refer to the points he's making in section 166 as a response to that kind of argument. So I wouldn't want to push that too far, in respect of the fact that it's not. So I don't want to be unfair on Mr. on my learned friend or the trustees. Finally, learned friend referred to policy. He said it would be odd if an ombudsman's decision would satisfy section 91(6). He said there would be a real difficulty in making this distinction between determinations and reasoning. Well, I've already dealt with that point. In our submission, that's an unfair point given the purpose and what the Ombudsman is trying to do when writing his determinations. In our submission, determination, as I've explained to Lordships, is quite clear and can obviously be distinguished from the reasoning underlying the decisions on the points with which the Ombudsman had to deal. My learned friend's second point was that if the Ombudsman, in order for the Ombudsman to be, in order to be appropriate for the Ombudsman to be a competent court, that ought to require legislation to enable the Ombudsman's to be the Ombudsman's jurisdiction to be applied more generally. I'm not, for my own part, sure why that's policy, what that's got to do with policy. Ultimately, the policy underlying section 91(6), as I've said many times before, is the effective resolution of disputes, and in our submission, that's precisely what an ombudsman's determination.
Well, the stronger point is that because it's a one-sided procedure that's only available to the member.
Yes.
That's a reason for saying that pension ombudsman is not a court.
Well, in our submission, that's not right.
Is there any other case? Can you think of any other situation in which a court is only available to one side? I can't.
Well, I mean, to say one side is perhaps
well, in the sense that the jurisdiction to act can only be invoked by the members. It can't be invoked by the trustee. Well, I mean, the trustee might be said to provoke the member into doing it.
In this case, that's right. In fact, the Ombudsman's jurisdiction is far wider than that, and many other parties are able to bring complaints or refer disputes to the Ombudsman. So it's not the case that it's only the members, but it is absolutely true to say that the Ombudsman is not there in order to deal with complaints made against members. That's a policy decision that's taken. But in our submission, if one looks at it practically, whilst it might be the case that in that situation the trustee would therefore have to go to court, you've still got the situation of asking, in the situation where the member does instigate a complaint, and I submitted your Lordships this morning as to why there were many reasons why a complaint would want to be initiated, and why the Ombudsman's the Ombudsman Forum is an appropriate one to deal with that. Once that's done, then the members' issues, the members' complaints, the reference is dealt with fully and comprehensively by the Ombudsman and is subject to a binding determination. In our submission, those are by far the more relevant factors for determining whether the Ombudsman is a court. In our submission, whether or not there may be an exclusion on jurisdiction is neither here nor there. I mean, just taking another example, exclusions and jurisdictions are legion. The county court obviously has monetary exclusion limitations, and there are certain courts which have exclusive jurisdiction over various areas. So it's not the case that to be a court, you've got to be able to hear everything from everyone against everyone. There are limits that are placed for perfectly good policy reasons.
Yes, but most courts operate on the basis of equal access, at least, don't they?
Well,
But you may have limitations on the subject matter that you can determine as a court, but you would not say you're claimant only or defendant only, would you?
well, if one looks at it a little more broadly and say, are there limits on the origination, the institution of the originating process, then that is something which inferior courts are by nature subject to. I'm not saying that there isn't a distinction. I'm not saying that the Ombudsman has the full powers, the full panoply of powers that other courts have. But the question I'm asking is whether that, or the suggestion I'm making is that point does not outweigh the other factors that are in favour of the Ombudsman being a competent court in the circumstances of Section 91(6) and the policy reasons that I've identified as to why an order of the competent court is necessary in that situation.
Yeah.
Okay. The final point I wish to make was that if the Pensions Ombudsman is not a competent court, even if we're wrong on that, then I just wanted to pick up and run with my Lady Justice Whipple's point this morning, which relates to what Section 1515 is really about, which is that it's a deeming provision. Section 1515 says any determination or direction of the Ombudsman shall be enforceable in England, Wales and the County Court as if it were a judgment or order of the court. So it deems the determination to be enforceable as if it were a judgment of the county court, and we therefore say that the Ombudsman's determination, coupled with that deeming provision, satisfies the requirement for an order of the county court as the competent court. And our submission is that analysis entirely consistent with the policy of Section 91(6), which, as I've said, is to permit the member to have their dispute effectively resolved by a suitable tribunal. For the reasons we gave this morning, in our submission, the Ombudsman clearly fits that bill.
So that's the reading of 1515A.
Yes.
There would be no need for the regulations about enforcement by the county court, because you're saying the Pensions Ombudsman's determination, if one looks at 1515A, should be treated as if it were.
No, because there's a difference here. That it may well be the case that certain directions and determinations of the Ombudsman do need enforcement in the sense of the use of the enforcement powers granted to the county court, so sequestration and equitable execution and those kinds of things. But in this case, where you don't need to enforce, and there's no need to enforce, as I've said before, A, why require enforcement in this case, and B, here is a way to fulfil that purpose by deeming the Ombudsman's determination as if it were a judgment or order of the county court for the purposes, in circumstances where the coercive enforcement powers of the county court aren't required.
Thank you.
Unless I can assist your ladyship any further, those are my submissions.
Okay, thank you very much indeed. Well, thank you all of you for your interesting and helpful submissions. We obviously will reserve our judgment. We will let you have draft as soon as we can. When you receive the draft, it's for notifying the court of any typographical corrections, not for inviting the court to revisit the issues in the case. Please pay attention to the rubric of the embargo at the top of the draft judgment and ensure that that's complied with. Otherwise, as I say, we'll let you have something as soon as we can. Thank you.
Thank you.
Court rise if able.